I had the sentence written down before I said it. The yellow pad was open beside my right hand. Wade Mercer was standing at the defense table waiting for me to speak. Then he reached inside his jacket, and in the half second before anyone moved, I saw what he had decided to do with the rest of his life. It was not his service weapon. I knew that even before it hit the floor. It was a short revolver with dull blue steel and a worn grip, the kind of gun a man carries when he wants a second option that nobody logs. I still think about the way it slid across the wood and stopped against the brass rail below my bench. I think about that more than I think about the sentence. If you want to hear the rest of this, and I think you should subscribe and turn on notifications. I am not saying that for the numbers. I am saying it because this story deserves more ears than it has gotten. Hit subscribe. Then let me continue. Before that gun ever came into my courtroom, I knew Rachel Keene by the way she handled silence. She was 34 years old, a county payroll analyst, and she never rushed to fill a pause. Some witnesses talk faster when they are afraid. Rachel got more exact. If a lawyer asked for a date, she gave the date and the time. If someone asked where she stood, she gave the side of the car, the direction she was facing, and which hand held her phone. One thing she said on the first morning has stayed with me. My clerk offered her a glass of water before she testified. Rachel looked at the glass and said, "If I pick it up now, they will see my hand shake." She said it quietly, not for sympathy, just as a plain fact. Then she folded her hands and told the truth. Wade Mercer was 51, sheriff of Red Hollow County, 2 elected terms. He sat still when people watched him and moved only at the edges of attention. He checked the exits. He watched the deputies more than he watched the lawyers. When witnesses walked in, he did not look at them first. He looked at the jurors looking at them. That told me a lot. Outside my courtroom, people knew him as a church deacon, a donor, a football booster, a man who shook hands and remembered names. Inside my courtroom, I watched what he did when he thought nobody important was watching. He touched his cufflinks. He straightened papers that were already straight. He measured the room like a man who had spent years expecting it to move around him. The case file said the incident happened on March 11, 2025, at 7:43 p.m. in the North Employee parking lot behind the Red Hollow County Administration Annex on Keller Street in Benton Falls. I was not there. But by the time trial started, I had read every report, heard every witness, and listened to the recovered phone audio enough times that I could picture the wet pavement and the yellow security light over Space 18 as clearly as if I had stood there myself. Rachel Keene had found overtime records that did not match transport logs from the sheriff's office. Then she found county fuel charges tied to a private fishing trip on the Gulf. She copied the records, printed supporting receipts, and told her supervisor, that is what started all of this. Not revenge, not politics, paper. She left the annex late that night carrying one canvas tote, one phone, and a dark green folder. Wade Mercer stepped out from between 2 county SUVs before she got her driver door open. Rachel said he told her, "Give me the folder." She said no. He took her phone. He pressed her against the car door. Then he pulled his jacket back just far enough for her to see the gun. He said, "Do not make me handle this in a way we both regret." That line came into my courtroom more than once. It came through Rachel's testimony. It came through the phone audio. It came through the mouth of a deputy who heard Wade repeat himself the next day. The words were not loud. That was part of what made them settle into the room the way they did. The case reached me in an unusual posture. The local district attorney recused because Wade Mercer had campaigned beside him, and one of the sheriff's investigators was related to the prosecutor's office. A special prosecutor came in from Mason County. The defense moved to change venue. I denied the transfer but ordered outside courthouse security. No local deputies in the hallways, no favors, no familiar badges near the witness room. Most people do not know this, but when a witness says a public official used authority to scare them, the court does not only think about trial testimony. We think about elevators, side corridors, parking lots, lunch breaks, and restroom routes. Justice is not real if a witness has to pass the same power that frightened them just to get back to their seat. On June 2, 2025, Wade Mercer signed a waiver allowing immediate sentencing if convicted. That mattered later. It meant I would not have to wait weeks after the verdict to impose sentence. He signed it because he expected to walk out. I remember the date because I circled it in red when I read the file. On the first day of trial, Rachel entered through the side witness door at 8:56 a.m. She carried that same dark green folder, though by then it was empty and marked as an exhibit. She did not look at Wade. She looked at the clerk, then the flag, then the witness stand. Her shoes were flat black shoes with dried rain marks near the toes. Wade came in 2 minutes later through the defense door. He nodded to his lawyer, sat down, and checked the ceiling camera before he checked the jury box. His wife, Dana Mercer, was in the second row. His oldest son was behind her. Wade did not look at them first. He looked at my bailiff, Thomas Bell. Men who have spent years around force often know where it lives in a room. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I'm telling it. Subscribe. This is what I do now. Tell the stories that need to be told. The evidence came in 3 waves. The first wave built the floor under the case. Rachel testified. Her supervisor testified. County payroll records came in. Fuel purchases came in. Vehicle logs came in. The state showed that 4 deputies had claimed 11 hours of overtime on a date when only 1 transport occurred, and that a county fuel card was used 68 miles off route at a marina supply store. That did not prove the parking lot assault by itself. What it proved was motive. Rachel Keene had records that could embarrass Wade Mercer, and he knew she had them. Rachel told the jury what happened in the lot. She said she kept her voice low because she did not want him to feel challenged. That was the sentence that stayed with me from that first wave. I was trying not to make him feel challenged. People who have never had to manage another person's temper may not hear the whole life inside a sentence like that. I did. When we broke for lunch, I watched Dana Mercer stay seated while everyone else stood. She turned her wedding ring once, then again. Rachel's supervisor, Linda Phelps, crossed the aisle and stood beside Rachel without touching her. From the bench, I noticed distances. They often tell the truth before anybody speaks. The second wave complicated things, the way a fair trial is supposed to allow. The defense argued that Rachel had removed county documents without proper authority, and that Wade Mercer acted badly, but not criminally when he tried to recover them. They said the parking lot video did not clearly show a gun. They said no one saw him point it. They brought in a retired sheriff who testified that elected law officers often move too fast under pressure and that poor judgment is not always a felony. That was not a foolish argument. The video was bad. It showed Rachel pinned against the driver's side door of her Honda Civic for about 7 seconds. Then it showed her bend down and Wade walk off with something in his hand. But the camera angle was high and the sound was poor. If that had been all the state had, the room would have looked different. Then the prosecutor called Deputy Aaron Pike. He was young enough that his collar still seemed to wear him. He testified that the morning after the parking lot incident, Wade Mercer told him to mark 1 patrol unit camera, equipment fault, for the hour covering the annex lot. On cross-examination, the defense asked whether Wade ever used the words delete or erase. Pike said no. Then he said I should understand what kind of day I wanted to have next. I asked him to repeat it. He did. Nobody in the courtroom moved when he said that. But Dana Mercer closed her eyes for 1 long second. I noticed because I was looking at her husband when it happened. The third wave changed everything. A forensic analyst recovered 41 seconds of audio from Rachel's broken phone. The phone had hit the ground and the screen had shattered, but the recording app kept running. Most of what we heard was scraping, breath, traffic, shoe noise. Then a male voice came through. He said, "Rachel, I am not asking again." There was a pause. Then he said very calmly, "I did not come out here to leave empty-handed." The state also introduced a photograph taken after Wade Mercer's arrest. Inside the lining pocket of his jacket, the seam was freshly torn. The analyst explained that a short revolver often catches there when drawn quickly from a hidden pocket. It was a small detail. Small details win cases when they fit. Late that afternoon, Linda Phelps returned briefly to identify email timestamps. She was a plain witness in a plain suit giving plain answers. Then the prosecutor asked how Rachel looked when she came back into the building that night. Linda said, "She apologized before she told me what happened. I have not forgotten that sentence. Fear does strange things to decent people. I have told this story before, to colleagues, to my family once, and every time I get to this part I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it." The defense case deserved to be heard fairly, and I gave it that fairness. Wade Mercer's lawyer argued that his client had panicked over a leak of confidential records. He said Wade never intended physical harm. He said Rachel mistook exposure of a holstered weapon for a threat because the encounter was tense and personal. He said public disgrace had colored the way witnesses remembered ordinary bad conduct as criminal conduct. Then Wade Mercer took the stand. He was careful at first. He said he approached Rachel only to recover county records. He said he never meant to scare her. He said, "This county runs because men like me make hard calls." I wrote it down because that sentence told me how he understood himself. On cross-examination, the prosecutor asked if he showed Rachel the gun. Wade said, "I did not point it at her. I let her understand it was there." He said it in a low voice, almost polite. That was the quiet quote that was still wrong. Once he said it, the defense lost a lot of room. Then the prosecutor asked why he did not call county counsel, the county manager, the district attorney, or anyone outside his own chain of command. Wade said, "I had a bad week, Judge. I was trying to keep my office from being torn apart by rumors." That line tried to sound human. It also made clear what he was protecting, not the county, himself. There was one more quote. It came near the end when the prosecutor asked why he took Rachel's phone. Wade said, "Because once people start acting like they can embarrass you without consequence, it spreads." I wrote that down too. Sometimes a defendant tells you the whole case in a sentence meant to save himself. This is where my own memory came in, and I will tell it the way it came to me. I was 12 years old sitting in the passenger seat while my mother got pulled over for a broken taillight on Highway 19. The trooper was polite. He never touched his weapon. He did nothing wrong. But I remember my mother keeping both hands on the steering wheel until his lights disappeared in the mirror. I remember the breath she let out after. I thought about that breath during Wade Mercer's trial. I have been doing this for 19 years. I have seen a lot of cases. The ones I choose to talk about publicly are the ones I believe need more people to know about them. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. The jury began deliberating at 2:18 p.m. on September 22, 2025. They came back at 4:07. I remember because the coffee beside me had gone cold and untouched. The foreperson, Miriam Cole, held the verdict form with both hands, but only her left hand trembled. Rachel stared at the table. Wade stared straight ahead. I had made my legal judgment days earlier, if I am honest, not the verdict. That belonged to the jury, but I knew the state had crossed the line required by law. The clerk read the form. Guilty on aggravated assault, guilty on witness intimidation, guilty on unlawful restraint, guilty on official misconduct. Rachel put both hands flat on the table as if steadying herself. Wade did not move. Dana Mercer lowered her head and covered her mouth with 2 fingers. That was the first reaction I noticed. Because Wade had signed the immediate sentencing waiver, we recessed only briefly before moving on. We came back at 5:02 p.m. He had the right to speak before sentence, and I gave him that right. He stood and said, "You are making a mistake that this county will pay for." Then he reached inside his jacket. I saw the gun only after Thomas Bell moved. Thomas crossed the gap in 2 strides. State Marshal Elena Brooks came from the wall at the same time. Wade got the revolver halfway up, angled toward the bench, before Thomas drove his shoulder into him. The gun struck the floor, spun once, and slid to the brass rail below me. Rachel's chair hit the floor behind counsel table. One juror stayed standing because he had not yet understood where to go. Dana Mercer cried without sound. I stayed low until Elna had Wade's wrist pinned and the second marshal secured the weapon. Training takes over before belief does. The verdict was not the hardest part of this case for me. The sentencing was, because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. When order was restored and Wade Mercer was in restraints, I looked down at the yellow pad beside me. The number had not changed. I spoke slowly because sentences like that should never be delivered quickly. I said, I am ordering you to serve 28 years in state custody, with 22 years before release review, the maximum sentence allowed to this court on these counts in consecutive form. I am doing that because you used public office to corner a civilian, used fear to hide misconduct, and then brought a hidden weapon into open court after conviction. I have considered every argument for mercy. Your own actions defeated them. I said, I am also ordering a fine of $250,000 to the Red Hollow Court Security and Victim Recovery Fund. I am doing that because what you did not only injure one person, it forced this county to spend public money restoring safety where your conduct broke it. I said, I am ordering the permanent surrender of your peace officer certification and county firearm authority, and I am suspending your eligibility to hold any sworn law enforcement office for 15 years after release. That means no badge, no reserve commission, no armed courthouse security, and no official carry under any public appointment. I am doing that because authority tied to force cannot remain with you. I said, I am ordering 800 hours of supervised community service with the State Judicial Safety Program and the Red Hollow Women's Resource Center to be completed during any supervised release. It will be administrative work. You will not supervise anyone. I am doing that because you need to spend time in places where the cost of intimidation is counted in real lives. I said, and there is one more thing. You will write an apology no shorter than 1,500 words. It will name Rachel Keene. It will describe what you did without excuse and without the words if or but. You will read that statement in open court or by secure video, and it will be posted on the county records page for 30 days. I am doing that because secrecy fed this case. The record will not. I said, you will also pay full restitution for Rachel Keene's trauma counseling for 3 years, her home security system, the replacement of her phone, the repair to her car door, and the tuition she lost when she withdrew from night classes after this assault. I am doing that because fear leaves invoices behind. Then I looked at him and said what I had decided I needed to say as plainly as I could. I said, you did not only take a folder and a phone from Rachel Keene, you took ordinary safety from ordinary moments. Your family did not make this choice, but they will carry part of it. That is not an accusation, it is a fact. Public privilege is a loan, not property, and I believe you crossed that line on purpose. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. After I finished, deputies moved Wade Mercer through the side exit for in-custody defendants. As the courtroom began to empty, Dana Mercer stopped beside the defense table and picked up his tie clip from the floor. She held it for a second, like she did not know what it was. Then she put it in her purse and said to her son, "Do not look back." Rachel did not leave right away. She stood near the rail with Linda Phelps beside her and looked at the spot where the revolver had stopped below my bench. Then she said, "Can someone walk me to my car anyway?" Linda said yes, before anybody else could. That sentence told me more about harm than anything else in the record. When I finally stood up, the room felt used up. That is the most honest word I have for it. Wade Mercer appealed. The State Court of Appeals heard Mercer v. State and affirmed every conviction in the sentence. The court said the record showed calculated witness intimidation, abuse of official authority, and no error in the consecutive maximum terms after the in-court gun incident. The ruling came down on August 19, 2026, 11 months later. I was not surprised, but I was relieved. People always ask what happened after. I can tell you one thing that did. On September 30, 2026, by secure video from state prison, Wade Mercer read the apology I had ordered. I watched from chambers. At one point he said, I used my badge and my gun to make Rachel Keene feel trapped. It was the first full sentence I heard from him that did not try to hide somewhere. And Rachel changed too, though in a smaller way that meant more to me. On January 12, 2026, she returned to the courthouse for an unrelated county records hearing. She came in alone carrying a takeout coffee and a blue notebook. No escort, no supervisor. Later she told the clerk, "I drove myself today." The clerk told me afterward. I have remembered that sentence ever since. Later still, after the prison apology, Rachel filed one short response for the record. She said, "That is the first time he said my fear out loud." That was all she wrote. The question this case left me with is one I still cannot answer neatly. When does duty turn into appetite for control? I do not mean the moment of the crime. I mean the earlier turn, the private turn, the one where being corrected begins to feel, to the person in power, like being injured. I learned something in this case that I do not think leaves a person once they see it clearly. Some people do not misuse authority because they lose control. They misuse it because control has become the only proof of self they trust. Once that happens, even a clerk with a folder can feel dangerous to them. If you know the feeling Rachel Keene carried into my courtroom, then you know the work of making your voice smaller so someone else does not grow louder. You know how your body learns exits before your mind does. You know what it is to apologize before describing your own harm. If that is you, hear me clearly. The careful way you survived was not agreement, it was survival. And if you recognize yourself in Wade Mercer, or even in part of him, I have one question I wanted to ask but could not ask from the bench. When did being challenged start feeling to you like being wronged? Sit with that honestly. Then hand over one piece of control for one full day, and notice what rises in you when you cannot use it. Start there. I still see the yellow pad. I still see the number I wrote before the gun came out, before Thomas Bell moved, before the tie clip hit the floor, before Dana Mercer told her son not to look back. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments are where people who care about the same things find each other.